Advocate Budlender.
Thank you, Chairperson. Chairperson, the questions that you've just asked my colleague, the evidence leader, I will respond to as well, since they are clearly questions that concern the panel, but I'll do so towards the address, with your permission. Chairperson, members of the tribunal, let me start to file written submissions and also to address you today. These proceedings have run on and off since January this year, and they have not been easy for anyone involved. We've said repeatedly, and we've been criticized for doing so, that these proceedings are unprecedented. But they are indisputably so. And it's not because sexual harassment is not common. We know that it is incredibly common. But it's because this is the first time that a sitting judge has had a complaint referred to a Judicial Conduct Tribunal on the basis that the complaint establishes a prima facie case, which, if substantiated, is likely to result in a finding of gross misconduct. How this tribunal deals with this complaint will set the standard to which we hold our judiciary, will send a message to the public at large about what we consider to be appropriate behavior from a judge and what is not appropriate. This case raises complex issues, but the question that sits before this tribunal is not complex. It is contained in the terms of reference, which provide, and I quote, "The allegation is whether or not, as a result of the conduct referred to in Ms. Mengo's complaint, Judge President Mbenenge is guilty of gross misconduct in terms of Section 177 of the Constitution." And I'll come in the course of my submissions to an analysis of Section 177 and of the meaning of gross misconduct. But for purposes of this introduction, let me say this: we will submit that the conduct which Judge President Mbenenge himself admits to, let alone what he disputes, that it in itself amounts to sexual harassment, and that it is conduct which we will contend constitutes gross misconduct as envisaged in Section 177(1)(a) of the Constitution and Section 14 of the Judicial Service Commission Act. We know that sexual harassment is prevalent in our society. We know that. We've quoted statistics in our heads of argument. Our heads of argument refer to a report by Judges Matter, which reference the fact that sexual harassment in the South African legal profession is more prevalent than the global average, and that 43% of women in the legal profession have reported experiencing sexual harassment, and that 25% considered leaving or have left the profession. And that you'll find at page 41 of our heads. So this complaint is important. It is only about Ms. Mengo and Judge President Mbenenge, but it also is not. How this tribunal assesses the evidence and the conduct of the Judge President will likely determine whether other women with legitimate claims come forward with their cases. Now, clearly, this tribunal has to make its decision based on this case.
Sorry, I don't understand that point.
Well, if
you can't say how we do it will determine. Each case is adjudicated according to its own facts. We are going to determine this case, as I said at the beginning, according to the law and according to the facts before us. As what the outcome thereof is, we don't know.
Chairperson, as I was saying, it's clear that this tribunal will make its decision based on this case and these facts. But the import of this ruling will have an impact on how issues of sexual harassment are dealt with in the future. Now, it's not to say that that must sway your decision, because you must apply the facts. But we cannot pretend that when we make findings about how women are required to behave and how that behavior translates into whether or not there is perceived consent, for example, that will not have an effect on other women and whether they choose to come forward with complaints. That is the extent of my submission. This case is important, and we cannot pretend that it's just about these two people. It is not. Now, I have noted that the tribunal has, thank you very much, read our submissions very carefully and considered them, and I will certainly try and keep my submissions short and focused on key issues and themes. I've also noted, listening now to the evidence leader's submissions, that there are things that she has dealt with that I will try not to repeat. But I would ask the tribunal to bear with me because I've only just heard those submissions. I intend in my submissions to deal with the following issues. First, I'll provide a very brief overview of the complaint and the respondent's version. Then I will deal with the standards that we expect of judicial officers and how they apply to the respondent. Third, I'll deal with the correct definition of sexual harassment and its implication for the evaluation of evidence in these proceedings. And then fourth, I will respond to some of the arguments raised in support of the respondent through the course of these proceedings, but pertinently in the heads of argument of the respondent. So to start with a brief summary of the case to contextualize my submissions. The versions of the complainant and of the respondent are summarized in our heads from pages 29 to 47. I'm not going to repeat them. What's relevant is that we have evidence from the complainant who testified over the course of 10 days. 4 of those days were under cross-examination. We will submit that she was consistent, that she was open, and that she was honest with this panel. There may have been things where she did not have an answer, but she did not shy away from that. There may have been answers that we don't like, but she didn't shy away from that. She brought evidence to this panel that did not all portray her in a good light, but she brought all evidence that she had to this panel. So we ask that her evidence is considered in that context, and I'll respond in due course to the chairperson's questions around her credibility. Now, the complainant testified that she did not want to engage in either a romantic relationship or in sexual conversations with the Judge President, but that she felt compelled to respond to his messages because of their relative positions. She testified that the conduct was unwanted, that it was persistent, that it was of a sexual nature. She also testified that she said no on many occasions, and we counted these through the transcript. There are approximately 13 occasions on which the complainant said no, either specifically using the word no or using words such as "it is impossible" when asked whether she would melt by the Judge President, when she told him you must control yourself, and various other instances quoting the Bible verses where the first word 𝐼 means no. So in different ways, this complainant, if you look at the WhatsApp, said no many times during the course of this, 13 that we can count. She testified that she did not see the respondent as a romantic partner, but she saw him as an elder, a leader in the court, and at times a father figure. She testified that she was shocked by his advances and she was confused about what to do. In response, the respondent's defense can be summarized as follows. The respondent admits to having initiated WhatsApp conversations with the complainant. He admits that they were clearly of a sexual nature. He admits to having persisted in requesting sexual photos of herself, or rather naked photos of herself. He admits a request for them to be intimate. However, he says he was merely engaging in a consensual relationship, that this was a cultural practice, and that his attention advances were welcomed by the complainant. And overall, he says that it was objectively reasonable for him to assume consent in light of their conversations. So in short, he says these conversations were welcome, and there was no way in which he could reasonably have been expected to know that they were not. Well, we will argue that it's not just factually incorrect, but that any reasonable person in the position of the Judge President would have realized that his conduct was not just inappropriate, but it was unwanted and was in conflict with his obligations as a judicial officer. On the Judge President's own version, he admitted to having badgered her and persisted in his attempts to get her to send him photographs, to engage in sexual conversations, and to be intimate with him. In fact, in support of this, he testified that this was part of a cultural practice which permitted him to refuse to accept a no from her, from a woman that he was courting, because she couldn't have meant no in this ritual. Now, that was never put to Ms. Mengo, and I'll come back to that. Now, the logical conclusion of this argument, if it's held to be valid, is that it is permissible to persist and to badger a woman to engage in sexual banter with you, to send you photographs of herself, to be intimate with you, until she eventually gives in and engages. That's the logical conclusion of that argument, because it's clear to her that she has to engage at some point because you're not going to accept a no. So even if she engages because she wants you to leave her alone, that will be taken as consent on your part. That's the logical conclusion of that argument, which we say must not be held to be valid. In fact, we say that is the very definition of sexual harassment. It's unwanted sexual attention of a sexual conduct that is often persistent. It doesn't have to be persistent, but often it is. So while we go through the evidence and while I make these submissions, I'll ask this tribunal to ask itself whether the conduct that the Judge President himself admits to having done, just those, what he admits to having done, whether those conversations that he admits to having with a junior secretary in his division in circumstances where he's a leader of that judiciary is conduct that this tribunal considers to be in line with the Judicial Code of Conduct and in line with the standard that we expect of our judiciary. Because what is at issue here is his conduct. It's not her conduct. It does not matter whether you like the complainant. It does not matter whether you think that the way she chose to respond to his persistent badgering for sexual attention was how a perfect victim should respond. What matters in these proceedings is whether the Judge President's conduct meets the requisite standards of a judge. And we submit that it does not, that his conduct evinces a clear indication of sexual harassment, that it amounts to gross misconduct in terms of Section 177 of the Constitution. More than that, we submit that his conduct was so blatant and abusive that it has eroded confidence in the judiciary and that it has brought the institution into disrepute in the eyes of ordinary South Africans who watch these proceedings. The conduct to which the Judge President admits, if it happened in any other workplace in South Africa, would, I submit, constitute gross misconduct and would be a dismissible offense. And in the judiciary, where we are told to hold our judges to a higher standard, there can and there should be, we submit, no conclusion short of this. So that brings me to the question that this tribunal has to engage with, which is, what is misconduct? Now, the starting point of what this tribunal has to consider is gross misconduct in 177 of the Constitution. But what do we do where the Constitution doesn't specify what types of instances, what types of conduct will amount to gross misconduct? Well, in 𝐼𝐿𝐵 versus the Judicial Service Commission and others, that's cited in our heads of argument, but the reference is 2022 3 All SA 87, it's a Gauteng division. The court looked at what is gross misconduct and how it is to be determined. And they said the starting point is the Constitution, They said Section 177 of the Constitution provides that a judge may be removed from office only if the JSC finds that the judge suffers from an incapacity, is grossly incompetent, or is guilty of gross misconduct. And the court went through analysis and how that it was not helpful to consider the concept of gross misconduct in the context of, for example, labor law, which was one of the arguments raised. But that instead, and I quote, what constitutes gross misconduct must be understood in the context of the whole of Section 177(1)(a). When the other two expressly mentioned grounds for removal are taken into account, it seems incontrovertible that what is contemplated is conduct that renders the judge unfit for a judicial role. And that you'll find at paragraph 116 of the 𝐿ope judgment. So it's conduct that renders the judge unfit for a judicial role. The court also held, and I quote, that the tool of a threshold of misconduct, which intrinsically requires a hierarchy of sin, is mechanical. As such, it is dysfunctional to the purpose of Section 177(1)(a). What is required, the court said, is a fact-specific inquiry in the round into all the relevant events upon which foundation of finding of fact can be made, which is then subjected to a qualitative assessment as to whether a person who behaved in the proven manner is fit for purpose in a judicial role. So we will submit that if one is to apply, as the court says we must, a qualitative assessment of the evidence before this tribunal, we would submit that the Judge President is guilty of sexual harassment and that his conduct rendered him unfit for a judicial role. And that then constitutes gross misconduct as contemplated in 177 of the Constitution. Now, one cannot simply consider this without looking at what are the appropriate standards for judicial conduct, which also find their way into a determination of whether or not there's been gross misconduct. The respondent disagrees with us on this. They argue that the Judicial Code of Conduct finds no application in these proceedings. And somewhat curiously, they base this on the fact that the Judge President, they say, has not been charged with dishonorable conduct. And if he's not charged with dishonorable conduct, then one doesn't have to have regard to the code. Now, we respectfully submit that that's incorrect as a matter of law, that it misses the point and ignores the provisions of the Judicial Services Act. First of all, Section 12 sub 5 of the Judicial Services Act provides that the code shall serve as a prevailing standard of judicial conduct, which judges must adhere to. And then the code itself in item 10 of its preamble specifically states, Section 12.5 read with 14.4b of the Act, that's the Judicial Services Act, Commission Act, specifically provides that the Code of Judicial Conduct shall serve as a prevailing standard of judicial conduct, which judges must adhere to, and that any willful or grossly negligent breach of the code may amount to misconduct, which will lead to disciplinary action. So what we see here is a link, a very clear link, between the Code of Judicial Conduct and the Judicial Services Act. Both those things guide this tribunal, and I would submit that to make a finding of misconduct or lack of misconduct without looking at the Judicial Code of Conduct, it would be wrong to do so. Now, there are only, if one looks at the Act, there are only a limited number of grounds on which a complaint can be made against a judge. Those are in Section 14.4 of the Act. The complainant, in bringing her complaint, you heard from the evidence leader, she was not legally advised at that time. She did not identify any particular section of the Judicial Services Commission Act as the basis for her complaint. But Section 14.4 of the JSC Act specifies the grounds on which a complaint can be made, and we submit 3 of them may be relevant to this tribunal. Those are in Sections 14A, B, and E. 14A lists one of the first ground on which you can lay a complaint against a judge as being incapacity, giving rise to a judge's inability to perform the functions of judicial office in accordance with prevailing standards, or gross incompetence, or gross misconduct as envisaged in section 177(1)(a) of the Constitution. So gross misconduct is referred to in 14A. 14B deals with any willful or grossly negligent breach of the Code of Judicial Conduct. And 14E refers to any other willful or grossly negligent conduct other than conduct contemplated in paragraphs A to D above, that is incompatible with or unbecoming the holder of judicial office, including any conduct that is prejudicial to the independence, impartiality, dignity, accessibility, efficiency, or effectiveness of the courts.
Sorry, those then will be a misconduct other than gross misconduct.
Yes, it's an unusual framing in the Act. Gross misconduct is referred to in paragraph A. But paragraph A actually includes both incapacity, gross incompetence, and misconduct, which reflects the Constitution, basically. Those are the three main grounds on which you can impeach a judge. And then
my suspicion is that at some point we may have to focus on that except blah, blah, blah. We may have to, the category of conduct as opposed to category of gross misconduct. We may have to look at that more closely.
Yes. Chair, you raise an important point, because actually when one reads the respondent submissions, I may be misunderstanding the argument, but there is a fair amount of emphasis placed on what was reasonable, what a reasonable person in the position of the judge could have been expected to do, and that then triggers questions around gross negligence rather than purely misconduct. I would submit that that when one looks at all of that, these are grounds on which you can lay a complaint. Ultimately, the finding will be one of gross misconduct, because that links with Section 177 of the Constitution. But we can engage with that further if the panel would like to. Now, when one looks at the code, I don't want to, the evidence leader went into some measure of detail on some of the provisions of the code, so I'm trying not to repeat that. But it's important to note the aim of the code is to, quote, assist every judge in dealing with ethical and professional issues and to inform the public about the judicial ethos of the Republic. So that is the purpose of the code. And one would imagine that when a judge is in a position that he or she thinks that they need to evaluate their conduct or to question how to behave in a particular situation, that this code of conduct would guide and assist that judge. In fact, it says so. It's to assist every judge in dealing with ethical and professional issues. So it's important to look at this code in a case such as this. I've already mentioned that the Code of Conduct serves as a prevailing standard for judicial conduct, which judges must adhere to. It also incorporates the Bangalore principles, which are the internationally acceptable principles that South Africa has signed on to. And so there's an international aspect to these standards that we apply to judges. And one sees this where we refer to a case from the Ninth Circuit of the U.S. Court of Appeals, which didn't obviously refer to our code, but referred to their code, and that some of the language was very, very similar. This is because these are international standards that judges are held to in the countries that have signed on to the Bangalore principles. Now, Article 5 of the code was referred to by the evidence leader. Article 5 deals with the obligation to act honorably. Importantly, it provides that a judge must always, not only in the discharge of his official duties, so he must always act honorably and in a manner befitting judicial officers. There's an explanatory note to each article, as the panel will be aware, and the explanatory note to Article 5 explains that a judge behaves in his or her professional and private life in a manner that enhances public trust in or respect for the judiciary and the judicial system. So, and then it says a judge avoids impropriety and the appearance of impropriety in all the judge's activities. And then note 5 sub 4 says, judicial conduct is to be assessed objectively through the eyes of a reasonable person. So that is in line with the question asked of the evidence leader. The conduct must be evaluated objectively, must be assessed objectively. In our heads, we refer to 3 cases in support of this. We refer to the Mutata case, the 𝐿𝐽𝐵 case, and the US case that I've just referred to, the Kindred case. I'm not going to go into detail into those cases. They are dealt with extensively in our heads of argument. But suffice it to say this, that each of those cases, particularly Mutata, emphasized the importance of public perception, and that links with the idea of what a reasonable person how a reasonable person would assess the conduct in question. The respondents in their heads of argument suggest that the Mutata case is not relevant because in that case, Judge Mutata had already been convicted of a crime. But in fact, that misses the purpose for which we are citing this judgment. The respondents suggest that we are premature in relying on that because there's no conviction here. But that's not what we rely on it for. We rely on it because in Mutata, the SCA quoted the Supreme Court of Canada in relation to the standard expected of judges in general. And I quote, public confidence in and respect for the judiciary are essential to an effective judicial system and ultimately to democracy and founded on the rule of law. And the SCA in that case specifically explained that there is a link between the perception that a reasonable person holds of the judiciary and the effective administration of justice. And we quoted in our...
Sorry, but that picture is founded on the fact that Mutata was convicted.
No, it's not. If one reads the judgment, it is about his conduct as a whole. So it's not just about the conviction. It looks at the conduct of Judge Mutata in how he responded, the racist comments that he made when he was on the scene, and his behavior as a whole. And so this, what the Supreme Court of Appeal says about the perceptions of the Republic is about how we view judges' conduct. It's not about how we view judges' conduct once they've been found guilty of something. It's in general. And in fact, they say at paragraph 81 of the judgment that the Judicial Service Commission has been charged by the Constitution and the Judicial Services Commission Act to inter alia protect the integrity of the judicial system. In discharging that function, it had to be sensitive to the expectations of a reasonably well-informed and dispassionate public, that holders of judicial office would at all times remain worthy of trust, confidence, and respect, at all times. So, in our heads, you'll see that the SCA quoted Lord Phillips in a case from the Supreme Court of Canada, again, talking about the standards required of judges, the public perception of that, and the fact that the public requires, whether we like it or not, virtually irreproachable conduct from anyone performing a judicial function. And that the standards require is the appearance of that conduct, as well as the conduct itself. Chair, I see that it's 1 o'clock. I'm not sure if you'd like me to continue. I still have a fair amount to get through.
Yeah, I think continue where we'll have to stop maybe at 1:30.
Sure.
I think they will have to, the Secretariat will have to confirm with us whether we can go for lunch at 1:30. Yes, you can proceed in the meantime.
Okay. Then in line with this objective standard that the SCA in Mutata referred to, our heads also deal with 𝐿𝐽𝐵 judgment, which also talks about the importance for a judge to remain visibly and manifestly imbued with integrity and act with good judgment. And of course, as I referred to the US case. We submit that in Judge President Mbenenge's case, there is no circumstance under which it was appropriate conduct for him as a leader in the judiciary to engage in the manner that he did with Ms. Mengo. Now, I say in the manner that he did because there was a suggestion that there's nothing wrong with a judge having a relationship with the secretary per se. That, in fact, we were told that some judges have married secretaries. That misunderstands our argument. It's not to say that we don't think that there are instances in which there can be consensual, permissible relationships. There is no bar on relationships within the court system. What we're saying is that the manner in which this took place was inappropriate. Now, if the Judge President had genuinely wanted to engage in an open relationship with Ms. Mengo that everyone in the court was aware of, there was no secret about it, there's nothing wrong with that. There's nothing wrong with dating a secretary. But this, and what one sees from the WhatsApps is, and even from the respondent's testimony, is that's not what it was. This was about wanting to engage with her on sexual content only. This was wanting to be intimate with her without having a formal relationship. And Ms. Mengo said in her evidence that that is why she said to him, come out clear. Come out clear. Because her understanding of someone who wanted to have a relationship with you was that they would, in her language, propose. Now, that's not a proposal of marriage, but it is to propose a formal relationship. I would like to date you, for example. But she said in her testimony, and we can find the reference if necessary, that that was not what she received from the Judge President. What she received instead from day one was a request for pictures of herself, where she removed the top part of her clothing, kulula mutla. So this whole case may have been very different if a different relationship, if there was an intention to have a different kind of a relationship, and if that was conveyed clearly to Ms. Mengo, and if she was given a proper opportunity to say no, she said no, that was respected. That is not what this case is about, at all. And what we've seen from the Code of Conduct is that there is a standard required of judges, at a minimum, I would suggest, to make sure that when you're engaging with someone, you do so in line with that Code of Conduct. In your public life, in your private life, that's what the code says. You are always a judge. You are never not a judge, and you are never not required to comply with those standards, as high as they are. So with those standards in mind, I'd like to turn to the definition of sexual harassment. It's important to start by understanding what is sexual harassment and how this tribunal must seek to identify whether the conduct before you constitutes sexual harassment. And some of the questions from the panel, some of the evidence from the tribunal have suggested that a rather simplistic understanding of what is or what isn't sexual harassment. And the evidence of the experts was an attempt to show that it is not that simplistic. But I'll come back to that. Let's start with the definition. The respondents asked this tribunal to use the definition of sexual harassment in the Equality Act. And they say in their heads of argument that you'll find the definition of sexual harassment in section 1.1 of the Act. But you won't find a definition of sexual harassment in 1.1 of the Act. What you'll find is a definition of harassment on various bases. One of them is on sex and gender. That is different, we submit, to a definition of sexual harassment. And that's why we don't use the Equality Act, we use the Employment Equity Act. Well, it's one of the reasons. The Employment Equity Act itself addresses sexual harassment directly, squarely. It provides detailed understanding of what sexual harassment is, what processes must be used to determine sexual harassment, and provides a court, or in this case, if this tribunal considers it, this tribunal, with guidelines about how to deal with sexual harassment. So the Equality Act, we would submit, is not the right framework to use for understanding sexual harassment. The correct framework is to be found in the codes of good practice on the prevention and elimination of harassment in the workplace. Those are issued under the Employment Equity Act. But the most important indication that this is correct is that the Equality Act itself, in section 5.2, states that this act does not apply to a person to whom and to the extent to which the Employment Equity Act applies. So if the Employment Equity Act applies, as it does to Ms. Mengo because she's an employee, then you don't look at the Equality Act. You look at the Employment Equity Act. And if one was to have taken this to the Equality Court, for example, that would have been an argument raised about the correct jurisdiction of that, whether that court had jurisdiction. So the Employment Equity Act self-evidently applies to her. It is because she's an employee and that this conduct took place in the context of her workplace and in the context of her work as a judge or secretary. The WhatsApps make it clear that on various occasions, the JP would message her only about work, or that on other occasions he would always start with asking her work-related questions and then move on to the more sexual content. So, and we saw that when he asked about protests near the court, when he asked her what her judge was doing, all of those sorts of things. So this conduct took place in a workplace, and it is irrelevant for purposes of the law whether the judge president was Ms. Mengo's employer or not. Much was made of the fact that he was not her employer, but he doesn't have to be her employer for purposes of the Employment Equity Act. It is not necessary that he himself is an employee even under the Act. The Act specifically says that it applies to employees, but it also applies to situations in which third parties such as, and they list a series of potential third parties, outside contractors, for example, are accused of sexual harassment of an employee. So the Act squarely applies, and it is irrelevant whether or not Judge President Mbenenge is an employer of Ms. Mengo. His position is relevant to balance of power and to other issues, but not to whether or not the Employment Equity Act applies. The fact that the court system in general is considered a workplace is also made clear from the most recent sexual harassment policy that was issued by the Chief Justice in August 2025. I'm not suggesting that it applies to this case, but it is helpful for this tribunal to look at what the Chief Justice and the Office of the Chief Justice considers to be sexual harassment. And specifically in that policy, it states that the South African judiciary acknowledges that each of its members are in positions of considerable power, authority, and influence in relation to staff in the judicial working environment, members of the legal profession, and the general public. Sexual harassment is an abuse of power, and for this reason, it is a responsibility of every member of the South African judiciary to remain vigilant of how their conduct may be received or perceived by those with whom they do not share the same power, authority, and influence. And the respondents say the policy is not relevant. It is relevant. It's relevant to this extent. It codifies the existing law on sexual harassment. It sets out the standards required of judges' conduct and codifies them. Most importantly, it provides this tribunal with an indication of the manner in which sexual harassment is to be understood going forward and treated in the context of the judiciary. So it would, we submit, be an extraordinary thing for this tribunal to find that the court environment is not a workplace for purposes of this complaint, where the 2025 sexual harassment policy explicitly makes it clear that it is. But as I said, in any event, the 2005 code on prevention of sexual harassment makes it clear that it applies to employees, but also to people that are not employees in the engagement with an employee, and that is dealt with in our heads at paragraph 63. Now, in terms of finding a definition of sexual harassment, there are various codes that are set out in our heads of argument under the Employment Equity Act. In Campbell Scientific, Judge Satch, trying to remember which judge it was, but in the case, the relevant case is Campbell Scientific. I think it was Judge Savage, who indicated that the codes don't supersede each other. So one must effectively read all of those codes together to understand sexual harassment. So we detailed the various codes in our heads of argument from page 58, but in short, sexual harassment is defined as unwanted conduct of a sexual nature. The unwanted nature of sexual harassment distinguishes it from behavior that is welcome and mutual. Importantly, the code goes on to say that sexual attention becomes sexual harassment if the behavior is persisted in. So if there's persistence, although a single incident of harassment can constitute sexual harassment. And then, so that's one factor, and or the recipient has made it clear that the behavior is considered offensive, and or the perpetrator should have known that the behavior is regarded as unacceptable. So any one of those three factors would satisfy the definition of sexual harassment. I'll just refer the tribunal to the fact that the 2005 code, which is also set out in our heads, sets out a test for sexual harassment and requires a court taking this into account to consider a series of factors, whether the harassment is on the prohibited grounds of sex or gender, sexual orientation, whether the sexual conduct was unwelcome, the nature and extent of the sexual conduct, and the impact of the sexual conduct on the employee. Those are all relevant factors. The code also sets out different ways in which an employee may indicate that the sexual conduct is unwanted, and that includes verbal conduct, but also non-verbal conduct, such as walking away or not responding to the perpetrator. And again, that code applies broadly to workplaces and the working environment. Okay. Now, if I can then turn to this issue of a power imbalance. A power imbalance is, or an imbalance of power, is a common constituent of sexual harassment. Ms. Vetten testified to that. It's also recognized in the 2005 policy on sexual harassment, policy for the judiciary. Now, the respondent was at pains to contend that he had no power over the complainant, but the complainant contradicted this specifically. In fact, she testified to this power imbalance on several occasions. For example, on the 13th of January 2025, page 25 of the transcript of that date, she said, about why she responded to the judge's messages, she said, "He is a powerful person. We are in charge of the entire province. It was difficult to say no to him, although I said no, no, no on numerous occasions, but he did not listen to that or hear my no. More than anything, I was scared of how he was going to treat me at work because I do not know what he was going to do to me, and there was no one who was going to believe me if I were to convey my story." So her perception of the respondent's power is also evident in her trying to bring her concerns with the court manager, for example, to his attention. The Judge President had power in that division, and she recognized that he had that power, and that is why it was so difficult for her to deal with how, perhaps in a way that may have made all of this much simpler, it was very difficult for her simply to ignore his messages completely, for example, not respond to them, because it was the Judge President who was messaging her. Now, the Constitutional Court in McGregor, which is also quoted in our heads, looked very closely at the long history, an accepted history of this notion of a power imbalance and how it operates in the context of sexual harassment. And in the Constitutional Court case of McGregor, it was about a doctor sexually harassing an intern. And in that case, the doctor was not the intern's employer. The Department of Health was the intern's employer. But the Constitutional Court still found that that hierarchical level within the workplace amounted to an imbalance of power. and that imbalance of power was a relevant factor in determining sexual harassment. And this was also confirmed by Dr. Vetten, who talked about what she called unofficial layers of hierarchy in the court system, and that the power that a judge president would have to comment informally, for example, if asked about a secretary's performance or if they were any good. So an informal comment, even if he wasn't doing a formal performance review of her, for example, an informal comment to another judge may well have had very serious consequences for her. And the respondents tried to suggest that despite all of that, there was no power imbalance. They say Ms. Mengo is an adult. They say in their heads of argument she's outspoken, she could stand up for herself. They even say that she was set in her ways. But we all here know, we work in a court system. We know that the judge president is not just some other employee in a court. He is the judge president. He's the head of court for that whole division. Particularly this judge president, who we know from his own evidence is well respected in that province. So there's a clear undertone that's worth mentioning, that in the case advanced on behalf of the respondent, there's a clear suggestion that if a woman is on the receiving end of sexual harassment, she must speak up, she must rebuff the perpetrator, and she must move on. And if she doesn't, then she's consenting to this. And that, the argument goes, is whether she stands to lose her job, whether she may be attacked physically, whether her life may be in danger, whether she may be hurt in other ways, whether she will be forced to bear the consequences of saying no. How Ms. Mengo may have responded to some person in the street or in a bar or in a restaurant who said these things to her could never have been the way that she responded to her judge president. That we must accept as so. Women, Ms. Vetten says, are not always able to say no. They're not always able to say no to a boss, to an elder, to someone who wields power and demands respect. We all witnessed the respondent's testimony. We saw his demeanor.
Just in passing, you say they are not always able to say no. If they don't say no, how will you know they are saying no?
The way you know that someone is saying no is you look at the objective facts, you look at their conduct. Where a judge president asks someone on the first day that he's engaging with her.
Where the objective look does not provide the answer or it gives an opposite answer.
In this case, the objective facts show that she said no.
My question is where the objective test does not show a no.
Yes, if objectively you think that there was no rebuff, then sure, then there's no sexual harassment. But we submit in this case, there are so many instances in which she said no. In fact, she said no, I counted 13 times. But this tribunal cannot ignore the evidence of the expert. This tribunal cannot ignore the fact that women do not respond in the same way to every situation. I know this as a woman in the profession. A junior colleague is able to respond very differently to the way that someone in my position can respond. The same is true of Ms. Mengo in a court system. So we witnessed his testimony, the judge president's testimony. We witnessed his demeanor. We witnessed his cross-examination. This is not someone that's easy to stand up to. It may be easy if you're a judge or if you're a senior counsel. It is not if you're a secretary in that court. So it's imperative that this tribunal appreciate that nothing about how Ms. Mengo chose to react or how she reacted in that situation that she found herself was simple. She told you that in her evidence. She said, these were the things that were concerning me. He was my boss. I was scared of what might happen. She also said that she tried different ways to rebuff him. She said no. She ignored him. She refused to give photographs when asked. She got sarcastic from time to time. And she said, I asked her specifically, why did you engage in sexual banter with him? Why did you respond to his sexual questions? And she said she didn't know what else to do. Nothing that she had tried had worked. And she thought maybe if she engages with him, he'll leave her alone. That was her testimony. Ms. Mengo is not a perfect victim, But there are no perfect victims. There is no rule book for how we are meant to respond when harassed. There is no one way in which a woman responds. And Mr. Vetten confirmed that. And Ms. Vetten's qualifications as an expert on the subject of gender were not disputed. She was cross-examined on her knowledge of culture, but she was not disputed not to be an expert on gender. And this tribunal must take her expert advice, we submit, in that regard. Ms. Mengo was cross-examined for 4 long days. She was on the stand for 10 days. She's a strong woman, and she's resilient. That's true. But strong women are sexually harassed every single day in this country. And to suggest that because she had an opinion and that in the right circumstances she was not afraid to voice it, in the respondents' heads of argument, for example, they say she felt comfortable enough moving the photograph of the Judge President from outside her office. That made her bold. To suggest that because she can do all of those things in those contexts, that means that she could not be sexually harassed in this context. It's an unacceptable contention, with respect. And it's one on which our courts have already opined on, that experts on issues of sexual harassment have long recognized. And it's a dangerous argument, with respect, because it effectively says that only the perfect victim can be harassed. It says a perfect victim must be sufficiently meek and mild. She must also be strong enough to reject any advances outright, even from a superior and with someone who has power over her, and even when her job and livelihood may be at risk. So that victim does not exist. What does exist is the fact, as I've said, women behave differently in different situations, and that's why the objective test is what is relevant. That's why we say you must look at these WhatsApps as a whole. It's very important that one does not take WhatsApps out of context, that one looks at these WhatsApps from start to finish, and that one reads the conversations as a whole. And when one does that, one sees that there is a pattern to the behavior of the respondent. There is a pattern of persistence. There's a pattern of starting off by talking about work and then moving into sexual conversations. There is a pattern of not taking no for an answer. When, on several instances, Ms. Mengo refused to respond, and despite her silence, the respondent responded with the listening ear emoji, or 𝐬𝐻𝐾𝐿, silence, he said to her, as in, where is your response? So whatever she did, the respondent would not leave her alone. And we submit that when this tribunal looks at her conduct and questions why she responded in particular ways, you must not look at one line. You must look at the whole conversation. And you must see that it is correct that she, and I'll come to this in due course, she never initiated a single sexual conversation, not one. It's there in the WhatsApps. Ms. Vetten confirms it. Dr. Docrat confirms it. Not one instance of sexual conversation was initiated by her. And I'll come back to that in due course. So we submit there's an undeniable, clear power imbalance between the complainant and the respondent, and that the respondent exploited that imbalance to sexually harass the complainant. To suggest otherwise would be to ignore not just the jurisprudence of our highest court, such as McGregor and the Constitutional Court, but the views of the experts on gender. And mostly it would ignore what all of us working in a court environment know to be true. Listen, I'm about to move on to a new section. Would it be convenient to take the lunch adjournment now? Okay.
Yes, I'm just wondering, is the food nearby? Maybe we could come back at 2:15. We'll adjourn until 2:15. We'll finish today because we are going to sit until we finish.
That's fine with us, Chair. No complaints.
Just a matter of, I throw this for just just a matter of observation. Because Advocate Budlender, you made a statement to say that you counted no less than 13 no's, referring to the highs. I think it should be mentioned, in all fairness, that during the interpretation, some of the highs that we're referring to were interpreted as exclamations, not as no's.
Yes, no, Chair, I'm happy to put up a list of those no's if it would assist. It does not take into account anything that was disputed to be a no. But if it would assist, I'm happy to do that.
Yeah, you may proceed.
Thank you. Chair, the evidence shows a gradual and persistent escalation of the respondents' demands and conduct. So we went from the 8th June, which was the first WhatsApp exchange between the parties, where you saw the respondent asking simple questions about Ms. Mengo's child, about her appearance, how she keeps fit. And within the first hour of that WhatsApp exchange, he asked her for a photograph of herself, and then proceeded to continue to ask. She explained that she didn't have any. He kept persisting. He then saw what she says was a status picture of herself fully clothed that anyone could see. He says that's a photo that was sent to him, but whatever it is, what they agree on is that he said, asked her to send one with the top half removed. Under cross-examination, the Judge President explained this by saying that the reason he'd asked that, 𝐬𝐻𝐾𝐿 was because in the photo she was covered up and that he could not see her shape. And you'll recall he even made a hand gesture during cross-examination to depict the shape of a woman's body. You'll find that on day 8, 9 July 2025, pages 27 to 29 in the transcript. So and then from there on, the conversations escalate, the sexual content, which my learned friend calls salacious. I don't like that word, but the content of the conversations were sexual. When one looks at that, they escalated. They became more persistent, more frequent, and more sexual. And when one sees how these things escalated, from asking for a photo to asking about sexual positions, for example, asking to be intimate, saying it was possible that they would melt if they were together. We would submit that when one looks at that in context, it is not improbable that on the 14th of November, that the respondent called Ms. Mengo to his office, that he then escalated things even further and attempted to unzip his pants and pointed to his penis. That you will see that evidence on day 6 of the transcript, 20 January 2025, page 66 to 67. Now, on the question of the 14th of November, the chairperson asked a question around Ms. Mengo's credibility around the 14th of November, and if I understood correctly, the chair suggested that her inability to decide whether it was the 14th or the 15th of November amounted to a question around her credibility. If I've misunderstood the question, Chair, you will correct me, please. Let me say this, factually, at all critical points, Ms. Mengo has been clear that she was not sure if it was the 14th or 15th. She said that from the first time she reported this officially to Krokwana. And even then she said it was the 14th or the 15th. And he confirmed this in his evidence under cross-examination. You'll find that on day 5, 9 May 2025, page 47. When she was, we then had a tribunal meeting, like a case management meeting, I forget what they were called, a tribunal inquiry meeting, I think it was called, when Ms. Mengo's legal team were asked expressly to obtain a date from her. And if I recall correctly, it was for purposes of obtaining video footage. But she was asked to pin her colors to the mast and give a date, 14 or 15. And her legal team took instructions. There's submissions before the tribunal. And her instructions were that, to the best of her knowledge, it was the 14th. That's the first time she said it's definitely the 14th. And that has been her position in evidence since then. She was specifically asked on the 23rd of January under cross-examination about this, and she confirmed that as far as she knew, the correct date, as far as she could recollect, was 14 November and not 15 November.
Who came up with 15?
I think in the affidavit, in her complaint, she said there was language used around the next day. I think the language was the next day, which then suggested the 15th, and that raised the question. And she did testify that she wasn't sure and that she had tried to put together things that had occurred in that time period to pin down a date. But what's important is that that she has, it's not that she was inconsistent in her version. She has been clear that she wasn't sure it was the 14th and 15th, and when her legal team were forced to put something on paper, we asked her and she said, to the best of her knowledge, 14th. Now, the respondent is at pains to deny that the incident of 14 November took place, and it is interesting that that there is a vehement objection to the fact that the 14 November incident took place and to certain WhatsApps, sexually explicit WhatsApps. There's a denial that those took place. Those two things seem to be of particular concern. Now,
Advocate Budlender, I think there are problems around that issue. Isn't there a time when she was asked to indicate whether it was in the morning or in the afternoon, and she was not able to clarify whether it was in the morning or in the afternoon?
Chair, I can't quite recall. I'm happy to check and come. I don't want to make a submission that's not correct. I can't quite recall whether there was an issue of morning or afternoon.
I think it was sent out that she should tell whether it was in the morning or the afternoon. I think the chair requested that she tells us whether it was in the morning or in the afternoon.
I'll have a look at the transcript and see what was said. But we would submit that the respondent that the video footage that we saw and the concession by Ms. 𝐬𝐲𝐽 show that there was an opportunity and an occasion for the incident to have taken place on the 14th of November. Ms. 𝐬𝐲𝐽 said she could not say, she was not watching the Judge President's office all the time, and she did leave her desk. She conceded that. So it's possible, and there were other concessions, but it was possible that it could have happened. And we would submit that given this gradual escalation of sexual demands from the complainant, that it is more probable than not that the incident on the 14th November did in fact take place as she describes it. But even if this tribunal is unable to find that the incident of the 14th of November took place as she alleges, we submit that that does not negate a finding of sexual harassment here. That the remainder of the respondent's conduct evidenced on the WhatsApps alone, even if one is not even to look at all the WhatsApps, but simply to look at what he admits, we submit that that constitutes sexual harassment and gross misconduct. And the same applies to the other issues that he denies, the photographs, K89, that he denies having sent. If this tribunal is not comfortable making a finding that he did in fact send them, and we submit that you can make a finding. Mr. Moller confirmed that he could not rule out that the respondent had in fact sent them from his phone. But if you find that you can't make that finding, even so, we submit there's blatant sexual harassment here. The truth is, if one would just, well, I'll come back to this in due course. Let me keep moving for now. Now, if I can move on to the last substantive section that I'd like to deal with, which is just to try briefly to provide a response to some of the respondents' arguments that come up from the heads of argument. There is a refrain throughout the heads of argument, and there is a substantial section of the heads dedicated to this, that the complaint has only been made to embarrass and humiliate the respondent publicly. It's contended that the way in which this complaint has been handled by the complainant's team, legal team, and the evidence leader asks this tribunal to adopt legal principles specially tailor-made for the identity and personality of the accused, and I quote from the respondents' heads, to venture into some public humiliation exercise in the hope of evoking public outrage against the respondent. That is at the respondents' heads, page 5, para 7 to 8. So we would submit that's a suggestion without any merit. It's quite frankly not borne out by weeks of evidence and the documentary evidence that is before this panel. That's particularly in circumstance where the manner in which the respondent has allowed his defense to be run on his behalf involved a particularly brutal and humiliating cross-examination of the complainant over the course of 4 days. He permitted her to be, because he gives instructions to his counsel, he permitted her to be called a liar, to be accused of acting on behalf of some unknown third party, to be accused of undermining the broader cause of sexual harassment for other women, for all women, amongst many other things. So if anyone has been humiliated and demeaned in these proceedings, it's the complainant. What we saw unfold during cross-examination was enough, quite frankly, to put back the very noble attempts of our legislature and our judiciary to protect women from the scourge of sexual harassment. And the fact that the Judge President thinks that the way in which the complainant has run its case is designed to humiliate him really bears no resemblance to any facts that this tribunal has had placed before them. If the suggestion is that the fact that the Judge President had to sit through a reading through of his personal WhatsApps that he admitted to having sent, and to suggest that this was demeaning and humiliating, then it suggests that he knows that his own conduct was inappropriate and contrary to what is expected of a judge. Now, another argument that was raised for the first time in cross-examination of Ms. Vetten was that the Judge President, it was put to her that the Judge President would contend that what we see playing out in the WhatsApps was in fact a 𝐼𝐴𝐺𝐴 cultural practice, and that actually what was happening was that the Judge President was courting Ms. Mengo, and that this practice requires, on his evidence, persistence, and in effect not accepting no for an answer, because the way in which the practice evolves is that the woman has to be coy and pretend to refuse a man's advances until eventually she gives in and accepts a relationship with him. Now, the Judge President claimed that the use by Ms. Mengo of the monkey with the closing eyes emoji gave him an indication that that is what was happening, that when she used the monkey with the closed eyes emoji, she was indicating shyness. And that meant that they were engaged in this practice. Now, that defense was never raised with Ms. Mengo. It wasn't put to her. It wasn't put to any other witnesses. It wasn't raised in the Judicial Conduct Committee. It was raised for the first time in these proceedings. Was not raised in the respondent's affidavit. So this tribunal doesn't have the benefit of Ms. Mengo's response to that particular argument. But she was asked in evidence about what she meant when she used the monkey emoji and with the closed eyes. And it is notable that she did not mention being coy or shy. She said she was embarrassed. It was there to connote embarrassment. So her version is different to his on this. But in any event, the Constitution is clear. Everyone has the right to participate in their cultural practices, and the language of the Constitution is the cultural life of their choice and to practice their culture. But no one exercising these rights may do so in a manner that's inconsistent with the Bill of Rights. So in other words, a practice of culture must be consistent with the Bill of Rights. And ignoring a woman's refusal to be intimate with you or to send photographs of herself, clothed or otherwise, is self-evidently, we would submit, in conflict with her right to dignity and her right to equality, amongst others. So on the issue of the cultural practice, one, we submit this tribunal ought not to take that into account because it wasn't properly placed before you. It wasn't put to Ms. Mengo or to any other witnesses. And it's an opportunistic argument that was raised only under cross-examination of Ms. Vetten. Two, even if it is an argument that this tribunal wants to consider, we would submit that this tribunal must have reference to the Constitution and must take note of the fact that such a practice would, we would submit, not survive constitutional challenge for the reasons I've articulated. Now, to move on to the next issue. And again, these are issues that have come up through the respondents' heads of arguments. The respondents contend that the respondent could not have known that his conduct was not welcome. And they say in their heads of argument, and I quote, "Quite how the respondent in this case ought to have known that his overtures would be unacceptable is unclear." That's at paragraph 65. Well, I've made submissions this morning about various objective facts that he ought to have taken into account and that this tribunal ought to take into account in determining whether or not the conduct in concern at issue was welcome. But what's interesting in how the Judge President chose to deal with the situation in which he found himself as a judge is that he did not once stop and question his behavior. He did not question whether it was appropriate. He ought to have, had questioned whether this conduct, this sexual relationship with her, with a secretary, had the real potential to be unwelcome. The first time that he asked her if he wanted to just be friends came weeks after he'd been engaging in this kind of relationship. On day one, he asked her for he sexualized the conversation. On day one, he ignored the fact that she was very clearly refusing to provide him with what he wanted and making up excuses. I'm at the gym. I don't have any pictures of myself. I'll take some later. All of that happened on day one. On day one, he asked her for a photo with the top half removed. So it is, we would suggest, misleading. We would submit that it's misleading to say that the Judge President could not have known that his conduct was unwelcome. It is possible that there were instances in the conversations where he wasn't sure. Absolutely. We don't deny that. But what is absolutely clear is that sexual harassment happened on day one of this engagement, and it happened in various conversations thereafter. We do not suggest that it happened in every single conversation, but that is why Ms. Vetten's evidence is important. Sexual harassment, you can consent, she said, to one thing, but not to another. Sexual harassment must not be looked at here in relation to the whole WhatsApp conversation as if something that took months, that you're asked to look over months of communications to determine whether that was sexual harassment. Sexual harassment happened here on various instances in those months, and quite frankly, it happened on day one. That's the very clear, obvious finding we would submit. And we would submit that a reasonable person in the position of the respondent would, at the slightest suggestion that she was not responding to him or ignoring him, not have persisted by sending listening ear emojis or prompting her with comments like "twaka," silence, but that a reasonable person would have stopped engaging with her on issues of sexual content early on. And a judge in that position ought not to have engaged with her on these topics. So when the respondent asks how he was meant to know that his conduct was unwelcome, that is how he was meant to know. A judge has to, in all conduct, personal or professional, maintain the highest standards of integrity, To engage in a conversation like this where he asks for sexual pictures on day one that he first starts talking to someone is highly inappropriate. He ought to have stopped communicating with her. As soon as she stopped, she refused to give him photographs. On the question of, which was asked to the evidence leader by the chairperson about Ms. Moreletwe, the question seemed to suggest that that the fact, let me start here. There was a dispute between Ms. Moreletwe and the complainant about when Ms. Moreletwe left the complainant's hotel room. Ms. Moreletwe said it was 9 o'clock, the complainant said it was midnight. And there was a suggestion that that impacts on the complainant's credibility because she made up this midnight time as a way to challenge Ms. Moreletwe in some way. Now, we would submit Ms. Mengo didn't tailor a version or produce a version to attack Ms. Moreletwe. She was consistent that it was midnight. She was cross-examined about it. She was consistent it was midnight. In fact, she even says she gave Ms. Moreletwe a thank you card to thank her for staying late because it was so unusual for her to do so. She says the next time that, not the next day, but the next time when she came back to Pretoria, she gave her a thank you card specifically for staying so late. And that you will find in the transcript of 8 May 2025 at page 7. And it does not assist Ms. Mengo to lie about this. It does not assist her to say that she left at midnight instead of at 9 o'clock. But what is clear is that even when challenged, Ms. Mengo was consistent. She said she stayed late, it was midnight. It was so late, I thanked her specifically. Then the narrative that the complainant...
I must tell you, I think we don't understand it the same way,
okay.
the same context, because the bottom line of complainant's evidence is that when she was in Makanda to compile what she says was the second complaint, she didn't have any copy of the initial document. Lo and behold, these documents are identical. Even the grammatical errors are identical. With all due respect, it makes nonsense of the argument that she didn't have a copy of that one. It must have been embedded either in the memory stick or in her laptop. But my problem is this. She extends Moretwe's stay at the hotel in order to pave the way for the argument that she was not left. She did not have any copy of the document embedded in her laptop or in the memory stick. To perfect that argument, she extends Ms. Moretwe's stay at the hotel to 12 o'clock.
Chair, that is an argument that we would refute, that we would say it doesn't have merit. She said it was midnight because she is insistent that that's when it was. This tribunal will make a finding on that. But what is absolutely clear is that even this thing of the two complaints is a bit of a red herring. You can talk about her credibility, but go back to the WhatsApps. When you have to look at misconduct, when you have to look at what this tribunal has to consider, look at the WhatsApps. Look at the fact that Ms. Mengo hid nothing from this tribunal. She did not, and in fact, that's the next thing I want to talk about, which is that there is a suggestion that she tailored evidence, that she came up with versions. But if that was the person that was before you, she would not have given you every single WhatsApp on her cell phone after 2 years of having that phone. She provided that. She may have attached some of them to her complaint. But we've seen how many pages those WhatsApps run to. She took screenshots of some of them and attached them to complaint. But when the complaint proceeded and she was asked to give her cell phone to the evidence leader, she handed it over. And what we have before us is a full a full set of WhatsApps, that many of which make her look bad, quite frankly. If she was the person that was sitting here trying to construct a version, she would, I submit, have deleted things that made her look bad. She did not delete them. And when she's asked about the things that are difficult for her to answer, she says, I don't know, or I was frustrated, or I said this because I was being sarcastic. She tries to engage with it. This is not someone who's trying to hide evidence from this tribunal. In contrast, the respondent has deleted every single message from his cell phone. He admits to having done that. He didn't want his family to see it. That's what was his evidence, as I recall it. So you're faced with a situation in which this complainant, as we submit, come here, she may not be entirely consistent on every single fact that's put to her. But no complainant in a matter like this is consistent, can remember every single date perfectly. And if there are things that are inconsistent in her version that you find to be problematic, they do not negate the fact that you have WhatsApps before you that show sexual harassment. And once you have sexual harassment, you must get to misconduct. Now, Chair, we will submit that this case requires this tribunal to assess the conduct of the Judge President and to determine, as we've said, whether his conduct amounts to gross misconduct. The evidence is lengthy and voluminous, and it requires this tribunal to venture into realms of WhatsApps and emojis and sexual innuendo. It's messy, it's uncomfortable, it offends our sensibilities, but it must be done. And as the tribunal does this exercise, embarks on this exercise, I would ask the tribunal to bear in mind that the expert evidence before you and the evidence of the code on good practice under the Employment Equity Act says sexual harassment is not just one incident, it's persistent, but it doesn't have to be. And what we see in these WhatsApps, as I've said, is that day one of the WhatsApps constituted sexual harassment. This panel must therefore ask itself, on a conspectus of all the evidence, whether the conduct of Judge Mbenenge, not the conduct of Ms. Mengo, the conduct of Judge Mbenenge is conduct which is acceptable of a senior judge and leader of the judiciary, and whether it's conduct that if it was repeated by other judges in the future would meet the standard that we require of our judges. If not, then you must find him guilty of a breach of these standards and of gross misconduct, for the simple reason that he ought, at a minimum, to have known that what he was doing was wrong and in conflict with the requirements of his office. And so we would therefore ask this tribunal to find Judge President Mbenenge guilty of gross misconduct. Chairperson, I haven't dealt with various things that are in our heads only because you've given us an indication not to do so. You've read the heads carefully. But if there are other issues, I'm happy to deal with it now or in reply. Thank you.
One of your early statements, Advocate Budlender, was, this matter is not complex. I don't know, I'm not sure whether I should agree with you.
Chair, I said the question for you was not complex. The matter is complex, certainly.
At the end of the day, isn't this the question? Well, let me say, actually, should we find that the persisted with his communication with the complainant, even though it was clear that his messages or his approach was unwanted. Unless Mr. Sikhakhane argues otherwise, the likelihood is that we'll find that there was sexual harassment. If somebody persists in a conversation like that, where it is clear that communications is unwanted, the likelihood is that we'll find sexual harassment, which therefore means that the real question in this case is where this message is unwanted. Is it clear that these messages were unwanted? I think that's the main question. And we'll have, in answering that question, there are a lot of factors that we'll consider, and so forth and so on. And perhaps, as they say, the devil lies in the details. There are so many aspects to this case which we will consider. What I would like to raise is, I think maybe I asked for this about the messages that if we find that have been initiated by herself, we have discussed that. Were there any flirtatious messages from her? If we find that there were flirtatious messages from her, then what do we do with that? But your argument is there were no flirtatious messages from her.
Yes.
Is that what you say?
Yes, we can't deny that there were messages in which she responded to the sexual questions, like when asked, I don't want to put the wrong words to the panel, but you recall the incident where she said, she was asked once about sexual positions, and she said she likes the word surprise, something to that effect, I'm paraphrasing. We don't deny, and we put to her, we said to her, why did you engage in this way? And she had an answer for it. And her answer was, she just had enough. She'd said no so many times and he wouldn't accept it that she thought maybe if she engages with him, he'll leave her alone. So she had an answer to that. But what's important...
No, but hang on. If the respondent suggests
that shows that it was wanted,
and then she responds, she's not keeping quiet.
But she
says she's not saying no. She actually says, I prefer a sexual position which comes as a surprise. That is actually an elaboration on what was initiated by the... She didn't initiate that, of course, but then it's an elaboration.
No, it's a response. She said, I like the word surprise. We'll pick up the exact language for you. But the point is, Chair, that's why I said, you must not look at a line out of context. You must look at these WhatsApps in context. So you must look at a conversation. And Leader Vetten said that in her evidence. She looked at conversations. Look at a conversation in determining, whether or not, whatever the question is you're asking, whether there was misconduct, whether there was sexual harassment, whether there was consent. But the point is, the context is important. And when you look, you have to read, I keep saying you have to look at all the WhatsApp so that you see what I call the escalation of this relationship. It's not that this one question about sexual position comes out of nowhere. It comes at the end of months of engagement around this and pushing the boundaries to ask more and more sexually explicit questions until she gives in and answers. So that's why I say the context of the conversation is important. One cannot say, and it was not open to the Judge President to say that in relation to one question, she answered in a way that suggested that that was wanted. That question may be fine. But in relation to all of the many other instances in which he suggested sexual things to her where she refused to respond or evaded, tried to avoid the question or ignored him, those were not wanted. And the truth is that if an ordinary person has to have this engagement with someone else? That's the question. What would a reasonable person think when you look at all of this evidence? We would submit that what is clear is she wasn't a willing participant in this. She was a woman in a position that she didn't know what else she could do. She tried saying no. She quoted the Bible. She refused to send things. And then she gave up. That doesn't mean sexual harassment didn't happen. Doesn't at all. Sexual harassment happened, because if that were true, then we could never find sexual harassment, because sexual harassment has as one of its elements this persistence. And the persistence is designed to break down your boundaries. So if it is okay to say that eventually, after all of this persistence, when someone engages with you on sexual talk about your favorite sexual position, then that means that she wasn't sexually harassed from the beginning. That would be a wrong finding in my submission. It's also not, these issues are not being dealt with by this tribunal for the first, well, it's been dealt with by this tribunal for the first time, but these are issues that our courts have grappled with. Our labor court jurisprudence is replete with cases of sexual harassment and how to weigh up all of these things. And what that shows is that there are complexities around this, and it's not a simple question of, did you say no? I asked you for a photo, you sent a photo, and if you sent it, that was enough. It's not about that. In fact, she never sent a photo. But it's really about listening and reading Ms. Vetten's evidence to understand what people study about gender relations in this country and how men and women engage. That's why I say the way in which Ms. Mengo responded and how she chose to respond, it's not a simple thing. This is a complex thing. The fact that we're having these debates shows how complicated it is.
And you see, you spoke at length about the issue of power. Advocate Scheepers also referred to that. You know what Mr. Skakane's argument was, an engagement with Dr. Vetten. And I got the impression that Dr. Vettel's evidence was that from A to Z, I don't know whether my impression is correct. It was as if from beginning to end, in terms of power relations, at all times, at every turn, the JP was dominant from A to Z. Now, I don't want to get us entangled in that, except to say that the matter here too is not that simple. You know, a woman has been given by God, or those who don't believe in God, let's say by nature, with the power, absolute power, to decide who has access into her heart. That key lies in her hand. There's not even a duplicate key somewhere, like duplicate key to a Mercedes. That key to her heart is under her absolute control. That's the beginning of power, indication of power. And I become curious, if not uncomfortable, when a witness comes to say, from beginning to end, there was no display of that power by the complainant or by a woman. In this particular case, when Ms. Mengo says, I want money, isn't that an excess of power in terms of interaction? Is it not an assertion of power? The question should be asked. If you say you want pictures or what, I want money, isn't that an assertion of power? And when she says, when the respondent asks for something, she says, earn it. Earn it. Isn't that an assertion of power in that context? And when the complainant sends a message to the respondent, and she says, I would like the two of us to meet. Isn't that an assertion of power? I want us to meet at the time of my convenience, that is when she's available. I want us to meet in East London, at my place. In that context, is that not an assertion of power? And the respondent, if she wants to meet with the complainant, it is at the complainant's time of convenience, which she is saying in the message. She's saying, she decides which city they must meet. She says in East London. I don't think the mighty Judge President can, on that occasion, when he has got to go and meet, can go to Port Elizabeth when the message says East London. She chose East London. If he wants to meet with her, he must go to the city chosen by the complainant. And he was keen to do that. And then she says, in East London, at my place. Isn't that an assertion of power in that context? If you want your respondent, he wants to meet. If you are in the position of the respondent and emotionally you are overwhelmed or mesmerized by her, what power do you have except to agree to come to go to East London and to her room? And you have got to go to East London. She chooses the city. And she says, when in East London, you come to my place. In other words, when the respondent has go to East London, he can go to the city hall. He cannot go to the city hall. If he wants to engage, must he not meet complainant's terms at the time of my convenience to the city that I choose at my place? And isn't that, in that context, an assertion of power? And then, the matter doesn't end there. I just want to show you how complex this issue is. The matter doesn't end there. The respondent says, when we are there at your place, what if we melt and something, can we become intimate? She says, no. To me, it's an assertion of power. We can't. Why would it not be argued that these instances I've mentioned, and the one we mentioned before, where you say about sexual positions, she says, no, I don't go for that. I prefer a sexual position which comes as a surprise. It is her body. She's got the right to say that. It's her heart. Why should it not be seen also as, at least in that context, some assertion of power, the power that she has about herself? In that context, isn't that an assertion of power?
Chair,
I'm trying to say to you that we must be careful with how we engage these complex concepts of power relations. I mean, if she says, come to me and come to my place, Advocate Budlender, ordinary life will tell us that Zelensky, if he wants to talk to Trump, or Trump wants to speak to Zelensky, Trump can't go to Zelensky. Zelensky must go to Trump. Ramaphosa must go to Trump. Why? It is purely a question of power. You go. Zelensky is in a weaker position and power-wise and so forth. They must go to the big Trump. Now you have a situation where a lady says, if you want to see, I want you, for us, the two of us to meet face to face. You come on such and such a date which is convenient to me. You come to East London and you come to my place. Isn't that an indication of some power? I mean, for somebody to come here and say, from A to Z, there hasn't been any case of assertion of power by a woman, and a woman is always powerless. It's quite surprising. And look, I said to you that the woman has got power. We must recognize that when it comes to matters of heart. You know, when a beautiful, charming, elegant woman is there and a man wants her heart, and the man comes to her and then she says to him, you want me? Catch the stars for me. A man will jump and try to catch those stars. That is an assertion of power. And when a man wants to marry a woman and whatever, or when that moment comes, where does power lie? A man kneels, goes down on his knees, kneels in front of a woman and says, will you please marry me? That you kneeling in front of somebody, you humble yourself to the power that person has. So this notion that a woman may not have power, is it really well-founded and real? In relation to matters of heart, in relation to control of that key to her heart, over which she exercises that power. That's why you'll kneel in front of her. In that given situation, who is powerful? You humble yourself. So situations arise where a woman can assert power. And for anybody to say that a woman cannot assert power in any situation is an astounding evidence.
Chair, we do not suggest that there are no circumstances in which a woman has power. What we're talking about here is a workplace. We're talking about an engagement between the most senior person in a workplace and one of the most juniors. That's when we talk about the balance of power, it's in that context with what Ms. Vetten said. But in her summary, her witness summary, she talks about what I think you're alluding to, which is that Ms. Mengo, she says, attempted to exercise some agency within the limitations permitted by the complexities of this arrangement. On occasion, she resisted Judge Mbenenge's repeated transgressions of her boundaries in ways that were sometimes explicit and direct, as in refusing to provide photographs or engage in sex, and at other times in ways that were implicit, indirect, and ambiguous. There is no one strategy for dealing with sexual harassment that works under all circumstances for a woman. Now, and then she says finally that her changing responses are in keeping with the many ways in which women seek to accommodate, negotiate, and resist sexual impositions. Now, first of all, that's the context in which we're talking about power. But Chair, I want to suggest, and I've already said that I don't suggest that women never have power. That's not the suggestion at all. The balance of power is that. It's a balance. It's a shifting balance. I accept that. That was what Mr. Sikhakhane put to Ms. Mengo, that the balance of power may shift. Sure. But to suggest that women always have power and that women, as the Chair puts, have power over their heart, which here we're not talking about power of your heart, we're talking about power over your body. We're talking about an invasion of your most inherent private spaces. Sexual harassment is not about romance, it's about power and sex. And if it was that simple that women held that power to who they allow to invade that space, who they allow into their body, then we wouldn't be a country with the highest rate of GBV in the world. We wouldn't be that, because women would have that power. But that's why I say we're not talking about that. We're talking about a workplace context here. So it is in different situations, in romantic, consensual situations, yes, It may be within a woman's power to say, I accept you as my partner, I don't accept you as my partner, I want to have sex with you, I don't want to have sex with you. Yes, in perfect, consensual relationships. That's not what we're talking about here. This is an engagement between, as I say, the most senior and one of the most junior people in a workplace. And in that context, even where Ms. Mengo exercises her voice where she can. So I want to just, I think the chair's incorrect about her saying, you must come to East London, you must come to my house. Her evidence, and I've asked my attorney to try and find the transcript reference to you, the evidence was that she wanted to sit down and tell him face to face once and for all this was not okay. And the suggestion was they meet at court, not at her house, because that would be a safe space. There was another instance where he wanted to come to her house and he asked if there were people there and she said yes. He asked, I'm just looking at what the evidence leaders provided me, if you'd bear with me. Yes, if one looks at the transcript, page 1207, sorry, I think it's 1207 of the WhatsApp conversations, the respondent says, upon your arrival in East London, where will you be? And she says, my house. And he says, or we will have the conversation at the office. And she says, better. So it wasn't that it was going to happen at her house. But I haven't, this is what the evidence
can I just try to define you what, sorry, I appreciate your point about that. What I'm saying is, when a person comes to say, I mentioned the word A to Z, I don't deny that there could be that, but when a witness comes to say, looking at this case, there is no stage at which she exercised, the woman exercised power. It becomes problematic. That's
not what she said, though. That's why I read this part of the evidence.
That is the impression I got. If I'm wrong with Dr. Vettel's evidence, that if I misunderstand the evidence, to say throughout, there was no time, there was no occasion at which there's some indication of assertion of power by the complainant. I thought that was the evidence. If I'm wrong, then what I put to you must be incorrect.
Well, I've read, Chair, from her summary. I don't have her transcript before me, but my understanding of her evidence is that there were instances in which Ms. Mengo tried to assert some agency, is her language, within the limits of what she was able to do. And that agency was, for example, resisting or being blunt or where she's sarcastic. But to upset the Judge President, she was doing something in the context of her workplace to make the most senior person in her workplace angry with her or upset with her. I'm simplifying. But that's the balance of power. The balance of power is that in the context of her job, where someone in the context of your job makes sexual advances to you and you rebuff them, you are not sure what the consequences are going to be. And that's why sexual harassment in the workplace is such a difficult thing, that often it goes unreported because you're not sure what the consequence is going to be if you report it. So that's the balance of power. It is the same, for example, in a context that we understand as lawyers, that if a junior advocate was to rebuff a senior counsel that she was working with on a case, that she's not guaranteed that she will get work from him again, or she's not guaranteed that he won't tell other people that she's bad. So the balance of power is in the context in which it happens. It's in the workplace, and that has a particular importance to it. So when we make arguments about the balance of power, it's balance of power in the workplace. It's not balance of power in a consensual relationship where someone proposes to you and you have the power to say, I'm not interested. It's not that. But even in that, there are instances, Ms. Vetten recognizes, that Ms. Mengo tried to assert herself and tried to use what power she had. On the question of the money, it's not that she just asked for money. She said, if I were to ask you for money, would you give it? And her explanation when she was cross-examined on that was, I know that if you ask a guy for money, they run away. And so it was her attempt to say, let's end this thing. I'll ask you for money. And he then says, money is not everything, and she agrees. So, and that's it. And notably, she never once after that asked him for anything. She didn't ask him for a handbag. She didn't ask him for money. She didn't ask him for a holiday. She didn't ask him for anything else in the course of all of these months. And one would imagine that if what she wanted was in fact this kind of reciprocal relationship, that she might well have done so, but it's notable that she didn't. So,
there was something I wanted to ask.
No, go ahead, Chair.
For you to speak to it now before
Yes.
Mr. Skakane speaks out. I think you have alluded to it. And that is that the question of the omission of a series of messages, which Mr. Skakane, I presume, I would like you to deal with it to save time, even before
Yes,
it
sure.
comes. Which, some of which would show that she was not amenable to the approach. And the argument, if I understand it, is that a series of them were not alluded to in a complaint, and they were left out. And I don't know whether the argument is that they were exhumed by Mr. Muller. A series of messages which she allegedly left out and didn't even refer to them in a complaint, and that these messages were indicated that she was amenable to that. I could have left it to Mr. Skakane to develop his argument further, but the interest of program or progress, and just to give you a full platform to speak to that.
Yes. No, thank you, Chair. I've alluded to it in my attempt to rush through my submissions, but...
You alluded to it, you referred to the fact that some messages were deleted, blah, blah, and so forth. You referred to that, but
let me clarify.
To put it more pertinently.
The allegation is that when she filed her complaint, that she did not put every WhatsApp in that you now have before you in this tribunal. And so there's a sense that she was hiding things from the complaint. The first point is, when she did that complaint, she was doing it on her own. She wasn't legally represented. When she did the complaint, she wasn't advised as to what she should or shouldn't do. But in any event, the Act does not require her to put all her evidence up before attached to her complaint. I was just trying to find the exact language of the Act, but I'll find it and deal with it in reply. But the Act requires that when you make a complaint, that you must state the basis of your complaint and I don't want to summarize, but it does not require evidence. That's very clear. She didn't have to put every single piece of evidence. What she said she did is she took, when she was with Ms. Moreletwe, she took screenshots of what was on her phone, and then she started printing. And those are the things that found their way into the complaint. But she didn't hide evidence. That's our submission. It was what she thought was relevant. Now, whether she should have attached more, maybe this panel will find that, and in future complainants will know you must put absolutely every bit of evidence attached to your complaint. The point is that she kept that phone. She kept the phone with all the WhatsApps, everything. And she provided that when asked. She could have deleted
some of
things.
them were deleted.
No, what you have before you includes, there were things that went missing when she provided to the SAPS. She says that. But what you have before you is everything on her phone, which includes things that are not complimentary of her, which includes things that if she was hiding things, she would have deleted. We know that because she was cross-examined extensively on this vacillation and whether it was in fact unwanted attention that she was getting from the JP, because she left in there the full conversation between them over months. So this kind of narrative that she somehow hidden evidence, we would submit is wrong and it's misleading. It's not that. It's about what she chose to attach to her complaint, having no obligation to do that. In fact, she didn't have to attach anything to a complaint, but she did. And when asked to provide evidence to this commission, she provided it, all of it. So we would submit it's a bit of a red herring. But I can deal with it more in reply if necessary.
When the JCC considered the matter, you can attend to that.
I'm so sorry. Okay, go ahead.
When the JCC considered the matter, did they have all the WhatsApp messages that we have now?
No, they did not. The JCC was required to see whether there was a prima facie case. They had the complaint and what she attached to the complaint, and they had submissions. They didn't have oral evidence, I think. I wasn't involved at that point. There wasn't oral evidence. Yeah. But they had, Ms. Mengo at that point was legally represented, and there was submission, and as was Judge Mbenenge, and there were legal submissions made on behalf of both.
Do we know what conclusion would they have arrived at had they had all the WhatsApp messages?
We do not. But I stress there was no obligation on her to provide all the evidence attached to her complaint, and I'll find that provision in the Act for you. When a person complains, they are not a lawyer. Mostly, they may be advised. She was not advised. So one must be cautious about what we require of complainants. If what we require of complainants is to make a full case, including all your evidence, then we must say so. But the way in which the Act and the rules are structured suggests to me that that's not the case, because the JCC referred it to this tribunal to hear evidence on various issues that may or may not have been at issue for them, or an issue for them. That was the purpose of this tribunal.
Yeah, but that's not the point.
Now,
the point is, you may not disclose everything, but at the same time, you can't omit that which is not favorable to your case. You can't.
Not
You
sure.
must make an honest disclosure.
Yes, all I can say is that she took screenshots of what she thought showed sexual harassment, which was her complaint, and she attached it.
Yes. Mr. Skakani. Sorry.
Thank you, Ms. Budlender. I heard you mentioning that the complainant never sent photos to the JP. Is that correct? Because of my memory serves him well, the JP said there is one photo which she sent to the JP, and the JP commented on that particular photo, which the JP sent, which the complainant sent to the JP. It was not a profile picture. That's how I understood the testimony of the JP. So the assertion that the complainant never sent a photo to the JP, is it correct?
It depends what photo you're talking about. She, for example, kept posting pictures on her status. So, for example, the picture of her food, a picture of herself dressed, and he would comment on those. There's a dispute about whether some of those were sent to her. She says they were her status photos. But if you bear with me, I just want to check one thing with my attorney before I give you a full answer.
Yeah, but the way I understood the JP to be saying, in one of the comments, it was not a status. It was something, it was a photo which was specifically sent to him by the complainant, which is different from when someone picks up a profile picture and makes a comment. And he tried to make a distinction between those two, to say, but hang on, there was an instance whereby she sent me specifically a profile, not a profile picture, but a picture, and I commented.
A picture of herself?
Yes.
Can I check with my attorney?
Please do so.
If you'd bear with me for a minute. Mr. Mashaba, I think that what you're referring to is potentially at page 1167 of the WhatsApps, where there's a photograph that that the JP responds with I don't know what emoji this is, fingers touching, saying stylish. And there is a dispute between the parties about whether or not that was a picture she sent him. She says she didn't. She said it was her status that he was responding to. So there is a dispute on that issue. But she says she did not send him pictures.
Lastly, on the issue of the no, you say there were 11 no's. Are you referring to the ayes? Because I think...
No, in fact, I will provide a table just to clear up any concerns. There were a series of ways in which she said no, this is a submission. There were some times where she said the word no. There were other times where she quoted the Bible verse and referred to the first word. There were other times where she said no in different ways. It is impossible. It will not happen. You must control yourself. When I say how she said no, it's perhaps it's better to say how she rebuffed him, how she was trying in many different ways to say no. And I'll provide a table with all those references. This morning I counted 13, but I will provide a table to the panel.
Excellent. Thank you.
Mr. Skakan.
Yes, Chair. Thank you, Chair. I won't be long. May I ask for a short break? Remember